Good afternoon, everybody. We're not quite 3 o'clock, so there may be still some people coming in, but we will be getting underway very shortly. In the meantime, I'll just for those that don't know me, my name's Tim Lester. I'm the Chief Executive Officer for the Australian Forest Contractors Association. All of a sudden, for some reason, I was flicking back into old positions. And I'm coming to you today from Canberra, acknowledging the traditional owners who are the Ngunnawal and Ngambri people of the lands on which I meet, and I extend that welcome and respect to all Indigenous peoples and indeed all of our participants here today. AFCA is really pleased to be able to bring you this webinar. I will confess this is our first time using this actual system, so you may need to bear a little bit with us as we get used to how it actually works. You will see on your screen the opportunities to do both chat and Q&A. We're not running any polls today, so don't expect to do that. If you do have questions that pop up during our presentation, please use the Q&A function and we will aim to answer those as we go through. If you want to make other commentary or speak to other attendees, please feel free to use the chat. This session will be recorded and is being recorded so that we can then make it available to people who can't attend, and that will be fed out through the AFCA website. That's afca.asn.au, and that will be up there as soon as we can. I'm joined today by the very lovely Jennifer Rotili from the National Heavy Vehicle Regulator. We're here to discuss and provide an overview of the Log Haulage Code of Practice, which is currently in draft and being for consultation. That consultation runs through to the 18th of April. And your feedback is very, very much appreciated on that. So the course of today's webinar will have a presentation and Jennifer will be running through those key pieces, and then we will open it up for Q&A. As I said, there's the opportunity to do your Q&A through on the text-based. If you really do want to jump online and on camera, we'll work out the technology and see how that happens so you can ask your questions directly. There may be some issues with bandwidth, so we just need to keep on that as well. So with that, and just prior to bring up our slides, Jennifer, I'll throw over to you to do any introductory pieces you'd like.
Thanks very much, Tim. I'm here in Brisbane on Jagera and Turrbal land, and also acknowledge Indigenous persons past and present and emerging leaders. To introduce myself, Jennifer Rotili, I'm from the National Heavy Vehicle Regulator. I've worked with the regulator for coming up on 10 years. Currently, I manage the Safety Duties and Codes team, and that's a team of people who work with industry to develop codes of practice and who provide general industry guidance about chain responsibility. I'm joined today by Craig Minns, who's one of those team members. And Craig, some of you may know Craig already. He was intricately involved in the development of this code over the last few years in particular, and has been involved in a lot of the consultation and testing and development of the material in the code. Thanks for coming along. Sorry, Tim, did you want to say something?
No, I was just saying that with that, I think it's probably time to get underway, and I will just bring up the slides. So let me know if they don't appear. They should, if I tick the right button, we should get that onto your screen there now.
Thanks very much. So I'll let you know briefly what I'm going to do today. Talk a little bit about the code and the consultation process, next steps, and so on. I'm also going to do a whirlwind discussion of chain responsibility, because I think that's important context for what this code is and what it's supposed to do. There will be a question and answer opportunity at the end, And I think I'll only take about 20 minutes to go through this presentation. It might be easier to save your questions until the end. Now, some of you may have come to this topic fairly newly. Some of you might be aware that this code has been under development for many years, or there was an original version which many of you have seen, and we now have a substantially different version for you now. But with that, I'll start that discussion. So next slide, please, Tim. So Tim's already highlighted the end of the consultation period is the 18th of April. So you still have 3 weeks to provide feedback. And we do welcome feedback from you, because the purpose of this code is to assist industry. And if it's not doing that, then we need to know about it. In late April or early May, an assessment will be carried out by a panel of experts. That will be people from the NHVR, people from industry, people from other regulators, people with expertise. If the panel assesses that the code is suitable for registration, then it'll be registered in May or June. What usually happens is that the panel, having considered all the feedback, may make recommendations for some changes. So my team will then go away and draft some proposed responses or changes, and the panel will consider those. That's a slightly iterative process, but we hope that that will be finalised for registration before the end of the financial year at least. Next slide, please, Tim. So now let me talk a little bit about the Heavy Vehicle National Law and the part of that law that's relevant to parties in the chain of responsibility. I think a lot of people hear the term COR or chain responsibility, and for them it means a combination of all of the many different obligations within the Heavy Vehicle National Law. But in fact, chain responsibility is only 2 sections within the law. It's a part of the law that I would describe as duty-based obligations, or duty which have offences attached to them. Separate from the chain responsibility obligations is a very large number of prescriptive offences that apply to drivers and other entities. And those are laws that cover, for example, mass, dimension, load, restraint, fatigue, and so on. Next slide, please. And just to explain what I mean by those 2 different types of offence, a duty-based offence, or a duty, if you like, is something that tells the duty holder what they have to achieve, in this case safety, but doesn't tell them how to achieve it. That's because it's not possible to describe what would be effective in every single one of thousands of different variations of supply chains in the industry. And the standard for complying with that duty is to do what's reasonably practicable, which is a bit of a hint that tells you that this obligation has been copied from work health and safety law. It uses very similar terminology. It's a similar obligation, similar penalties. The difference is that this obligation doesn't apply to a workplace, but applies to the consequences of businesses' actions or inactions, the consequences as manifested when a heavy vehicle is on a road. On the other hand, our prescriptive offences tell you in detail what you should or shouldn't do, and they're often in terms of metres, seconds, kilograms, tonnes, etc. Much lower penalties for those. Those maximum penalties you see there on the right are maximums. Normally they're dealt with by an infringement, which would typically be 10% of that. However, the primary duty has very large penalties for serious breaches that involve risk of fatality and the element of recklessness and so on. So the code of practice is aimed at the duty-based offence. It's aimed at the parties in the chain of responsibility who have that duty. Next slide, please, Tim. That's a statement of the duty. It's a duty to ensure, so far as reasonably practicable, the safety of transport activities, and it's both that positive duty as well as a prohibition on duty on conduct that would cause, directly or indirectly, another party to breach the HVNL or another person to breach the HVNL or a driver to speed or commit other offences. That's a very brief summary. When we're looking at the Code of Practice, it's a tool that helps parties to discharge that positive duty in particular, which is a duty to eliminate public risks. Next slide. The definition here is the definition of safety, and there's a number of definitions in the law which, when you put them all together, you end up with this list of 5 things. So it's a elimination of risk to the safety of drivers and passengers, persons or property, the prevention of damage to vehicles or loads, or to road infrastructure, or to harm to the environment. So that's much broader than what we understand by safety in the work health and safety law, for example. And certainly the safety of drivers and passengers is the most important part of the duty, but there's other parts of the duty as well. Next slide, please. This definition of transport activities is an important one because this is the focus of the duty, if you like. Recall, the duty is to ensure the safety of a business's transport activities so far as practicable. So by transport activities, that's not just those 10 activities which create the definitions of the parties. The definition of the law says any activity associated with the use of a heavy vehicle on a road. So it's all of the other things that happen before a vehicle gets anywhere near a road. It includes how you purchase equipment, how you recruit and hire, how you train people, your systems, your communications, your business arrangements, the contractual arrangements you make, what your board does and reports and sees, how you monitor compliance, etc. So anything to do with the use of a heavy vehicle on a road. Next slide, please. And the next definition coming up should be one that's familiar to you already, and it's that definition of what does reasonably practicable mean, straight from the work health and safety law. It's basically a requirement to take proportionate measures based on the degree of risk. It does take into account not only likelihood and gravity of risk, it also takes into account what a party knows or ought to know about hazards, about risks, and about controls. I've highlighted those 2 parts of that definition, the knowledge and solutions part, because it's relevant for the role of a code of practice. We'll come to that in a minute, but in short, a code of practice is there to help parties understand those things. So it's a way to inform the industry. These are the hazards, these are the risks, and these are the controls. So I suppose that hands it over to the business to then make sure that they put those things into place. And finally, costs is there. Costs are only relevant if they are grossly disproportionate to the risk. In other words, a control being expensive is not an excuse, but there could be a situation where the cost is so out of proportion to a relatively minor risk that it might be a reason not to implement a control. Next slide, please. So those are the main elements of the primary duty. I just want to compare briefly what the primary duty looks like when we compare it with some of the prescriptive offences. So I've taken 2 examples. The first example is the obligation in relation to load restraint. And you can see there on the right, I've represented the obligation that falls on a driver and also on a person who permits a person to drive a vehicle that's not properly whose load isn't properly restrained. So that's a section of the law. It refers to the mass dimension loading regulation, and the legal requirement for load restraint is to comply with the loading performance standards. And you can see those represented there. That's that 0.8 G forwards and so on. You'll all be familiar with that. So that's that prescriptive obligation I was referring to. There's also the loading requirements, which is another part of Schedule 7, but for now, just focusing on the loading performance standards. When we come over to the primary duty, compliance with the primary duty isn't just about achieving those loading performance standards. It's about whether or not the party has done what's reasonably practicable to ensure that vehicles will meet those loading performance standards when they're on the road. And you can see it's a combination of measures. It doesn't happen just by one thing. It requires many different things to be put in place so that when that vehicle is on the road, that load is properly secured. Next slide. Thanks, Tim. And the next example is fatigue management. So again, there's a prescriptive part of the Heavy Vehicle National Law, Chapter 6, which goes into, some would say, extraordinary detail about how drivers of fatigue-regulated heavy vehicles must manage their work and rest hours. And you probably know that there's detailed requirements, there's scheduled hours, there's requirements to record information in work diaries, and there's requirements on record keeping. So that's that prescriptive obligation. And as I've highlighted there, that applies only in relation to vehicles that are fatigue-regulated heavy vehicles, which is normally vehicles over 12 tonnes. For vehicles under 12 tonnes, there's no obligations at all. There's obligations on drivers and on their record keepers, and that's all. But when we come over to the primary duty and look at what that duty consists of, the picture's quite different. Again, compliance with the work and rest hours is probably the outcome that's required, but to comply with that duty, to do what's reasonably practicable, requires a whole lot of actions or measures or systems or training or processes in the back end to make sure that when drivers are on the road, that they are not fatigued and that they are getting a sufficient amount of rest. And just noting, of course, that that duty applies to all heavy vehicles. So the primary duty applies to in relation to every vehicle over 4.5 tonnes. So, as I say, a snapshot of a comparison between two different kinds of legal obligations. And when we're talking about this code of practice, it's a tool to help parties in the chain of responsibility to comply with that one on the left, the primary duty, the green duty. Next slide, please. So how does a business comply with their duty? First question, am I a party in the chain of responsibility? I think that's fairly straightforward. If you're all on this, webinar, I'm assuming you know that your business is a party. The next question is to identify what are the transport activities that my business carries out. So, as I said before, it's not just about loading, unloading vehicles. It's all of the things that your business does that is associated with the use of a heavy vehicle on a road. And I'll turn in a minute to the structure of the log haulage code, the draft code. And one of the reasons that we've structured in that way is to try and make businesses focus their attention on what are the different activities that are related. Point 3, next question is, what are the hazards and risks? I think the risks are well known. The risks are that vehicles crash or that logs fall off, in a nutshell. And of course, there's a number of work health and safety risks to people who work in this industry. But those are the risks in summary. Identifying the hazards is much more difficult, and the hazards are the things that create or lead to the risks. And many of those hazards we've found in discussions with many people from the industry, many of those hazards are failures of communication, failures of coordination, systems not working properly, things of that nature. And you'll see in the code that a lot of the hazards are things like that, as opposed to a physical hazard such as, a hole in the road or a broken spring or something like that. So having identified the hazards and risks, the next question is, what can the business do to eliminate or minimise those risks? And of course, this is where the code of practice becomes useful to you. It provides you guidance about identifying hazards and risks, and also about controls which may or may not be appropriate for your business. And the next question then, of course, is, having implemented control measures, are they actually effective? Are they working? If not, why not? What else needs to be done? Should different controls be used? Should there be changes to the way the business operates, the way it operates in collaboration with other businesses and so on? And I haven't made a big deal of the executive due diligence duty, but I'll just mention that briefly now. So when a business is a party in the chain of responsibility, the executives of the business also have a duty, and that's a personal, non-delegable duty to use due diligence to ensure that the business complies with its primary duty. So this is a whole of business obligation. So it's not about what individual employees should be doing, although that's part of how the duty is carried out, but it's a duty that sits with the organisation or with the business. Next slide, please, Tim. So I just want to contrast perhaps the way the industry can use a registered code of practice and the use that the regulator makes of a code. For the industry, the code is there as an information resource. It's a record, if you like, of information that the industry knows or is expected to know. And in putting the code content together, that's what we've done. We've taken input and suggestions and information from across the industry. That's how the code has come together. So when you use the code, it's there to help inform you. It doesn't do the whole job for you. You can't open the code and find a list of things that you have to do. You have to do work. You have to use the code as that tool to help you do that risk assessment within your own business and then find solutions. We recommend that you focus not only on your own operations, but also on the way your operations have an impact on other parties. So is there something that you're doing that makes it more difficult for another party to do something safely? A lot of the time in the chain of responsibility space, we see businesses very much focused on monitoring the compliance of other businesses. What we'd like to encourage is for businesses to sort of turn that gaze inwards to see what are you doing or what aren't you doing that could be improved. I think the code can help in that way. We hope that it's a reference that enables some of those discussions with other parties. It may help you to set expectations, and in some ways it might also be a guide to setting up practices that are used across the board, because we know that when people are using similar systems, there can be greater efficiencies. From our point of view, from the regular's point of view, the code is primarily there to provide industry guidance to improve safety across the industry. In probably unusual or fairly rare circumstances, the code may be used as an evidentiary aid if the NHVR brings a prosecution for breach of the primary duty. And there's a section in the law that says that a code of practice, once it's registered, can be used as evidence of what COR parties know or ought to know about hazards, risks, risk assessments and controls. So just emphasise that again, it's evidence of what parties know or ought to know about risks, hazards and controls. So the code isn't there to tell you exactly what you have to do, but it's there to inform you. And once the code is registered, you are effectively deemed to know everything that's in the code. And when there is an assessment, or if there were an assessment of whether your business had done what's reasonably practicable, that assessment would be made in light of the assumptions about what you should know. We also use codes of practice, or can use codes of practice, when we're doing things like issuing improvement notices or supervisory intervention orders. So we sometimes look to codes to see what are recommendations of what businesses could do to improve their practice. Next slide, please, Tim. A couple of comments about how we've organised the code. It's quite different from an earlier draft that some of you may have seen. We've organised it around the different activities that go into getting logging vehicles on the road. We've done that instead of organising it around parties. In the past, you might have seen, and if you look at the master code, you'll see it's organised around, scheduler, consigner, consignee, and so on. Feedback that we've had is that people don't always know whether they fit into any of those legal definitions. So we've avoided using those. We've focused instead on the different activities that are carried out, making it easier, or we hope making it easier for businesses to identify which parts they do, so that they can home in on particular activities they do and the hazards associated with them. And this means that for many businesses, they will be looking at more than one section of the code. So they can't just sort of turn to, page 58 and say, well, this is the section for me. Each business will have to look through all the activities in the code to identify which ones they do or are involved in, and then start to do that assessment. The code is structured around activity, then hazard, then control. This is different from the way some other codes have been prepared by us in the past. We've done it this way because for this particular code and for this particular content, we found that it's easier to understand hazards by associating them with the activities where they can be controlled. That might not work for every situation. As I say, it depends a little bit on the overall content of the code. We've done it deliberately as well to try to reduce duplication in the code, so that we've ended up with, I think, 20 pages of hazards, risks and controls, rather than 30 or 40 pages if we structured it in a different way. Overall, this code is based on a systems approach to safety. So it looks not just at what's happening on the day, it looks at the before, the during and after. And it identifies that safety relies on multiple factors and multiple actions or inactions on the part of many people. We've also seen that for a large part of the feedback we've had emphasised the importance of information. Getting the right information at the right time was usually critical, or a critical part of managing safety. Next slide, please, Tim. I want to go back, this is the last time we'll talk about the law, but I just want to go back to highlight a section of the law which relates to the primary duty. And this is the section that emphasised that the safety of transport activities, aka the primary duty, is a shared responsibility of each party in the chain of responsibility for the vehicle. And there's some principles that sort of talk about the level and nature of each business's responsibility, depending on the functions they do, the nature of the risk, and their capacity to control, eliminate or minimise the risk. So that's not saying that only one party will be responsible. What it's saying is that every party has a duty to do what they can. And sometimes you'll see that one party can do a lot, another party can only do a little bit, and one other party can hardly do anything at all. But each of them still has a duty to do what's reasonably practicable for them. And it's that combination of all of those parts together which leads to safety. Next slide, please, Tim. And just by way of example, in the load restraint field, getting load restraint right relies on those different parts. It's not just about the equipment, although the equipment's important. It's also about how logs are stacked and sorted at the coop. It's about having the right loading equipment and the right loading area. Importantly, it's about training for drivers and loaders and other employees who can identify when things are being done well or not. And then, of course, it's also that communication and response about unsafe logs. That's not the whole picture, but that's many of the important component parts. And throughout the code, I think you'll see we've taken a similar approach, trying to break down what are the different elements that need to be in place to make things operate safely. Next slide, please. A question that many people ask is whether you have to follow the code of practice. If you turn to page 8 of the draft code, you'll see our attempt to answer this question in advance. And what that diagram, you probably can't see it right now, but have a look at page 8. What it emphasises is that the legal obligation is to do what's reasonably practical. So that does not mean that every party must implement every recommended control in the code. They must, though, implement controls that would meet that standard of doing what's reasonably practicable. So in some cases, that might mean that you've implemented 2 or 3 or 5 of the code recommendations, but the other controls that are recommended don't suit you, don't suit your business, wouldn't work, aren't available, etc. And then you may need to find other controls. In another situation, a business that works differently, that has a different risk profile, might only need to implement 2 or 3 of the controls. So again, the code is not a new legal requirement. Parties in the chain of responsibility already have legal requirements. That's that primary duty. And drivers and others also have those legal obligations we've described in those up to 300 prescriptive offences in the heavy vehicle national law. So that's the law that's already there. As I said, the code is there as a body of information which is taken into account when there's an assessment of whether a party has done what's reasonably practicable. Now, our roadside officers, or SCOs, we call them, safety and compliance officers, there's a couple of them there. The SCOs provided some very basic training in relation to each of our new codes of practice, because they don't investigate breaches of the primary duty. Our investigators take on those larger primary duty cases. However, our compliance officers are aware of the code, so that when they see something on the side of the road, they may use that information and use their knowledge of the code to sort of ask some more questions, to say, well, is this just an offence by a driver, or is this an indication of a larger problem up the road? You know, this is the 20th time we've seen a vehicle going to A or from B that's got this problem. So, yes, the code of practice, as I said, they're a tool to help you achieve safety, but it's not a new set of rules for you. Next slide. I think that's it from me, Tim. Is that my last slide? And
yes.
Okay.
Great. Thank you, Jennifer. I'm presuming that you were just about to say happy to take questions. The first question actually was, can we share a copy of the presentation, which I'm sure is okay, but I don't want to put those words in your mouth, which is why I actually haven't written them on the screen.
Yes, Tim, we're happy to share that, but I think I'll review the notes before we do that, if you don't mind.
Yes, no worries. So, so Mark, thank you very much for the question. We will share a version of the slides, which may not be exactly this presentation, but it will be one that we can circulate. I probably had a couple of questions, and note that we've had one from Pete Bother as well. So thank you, Pete. Jennifer, I was just wondering, I thought it was a big call when you said we're not going to talk about the law anymore, and I'm thinking, I'm going to talk about the law. What's the relationship between this code of practice, the master code, national heavy vehicle law?
Okay. Well, the master code, I should say that my team, or our team, is currently reviewing the master code. So the master code that you may know now will be quite a different beast in 6 months or so. In its existing form, it's highly focused on compliance. And when you see the new version, it will be much more like the log haulage code of practice. That is a focus on information exchange, parties working together, identifying different activities, trying to map out the different parts that go into a safety system. The master code, though, is also covered by that provision of the law that says parties are taken to know what's in the master code. So it's in that same space. It's knowledge that you are deemed to know, and both codes are relevant only to section 26C and 26D. So the codes are irrelevant for those 300 other prescriptive offences. They're relevant only in that question of what is reasonably practicable for a party in the chain responsibility. Does that answer the question?
Look, I think it does, but I'm sure that our viewers will, if they have other questions, can pop them forward. I should have said actually that the call today, we've got AFCA members, AFPA members, and very, very pleased to have them in the conversation as well as some others, including non-national heavy vehicle law states, particularly WA. So how do you recommend people from particularly Western Australia or the Northern Territory should read or interact with the code at this stage?
Yeah, it's a good question. I suppose we'd say that for anybody, we hope that it would be a useful document, a useful tool to improve safety practices in logging, which we know is a uniquely dangerous industry. But in terms of its legal effect, I think it would have almost no legal effect in Western Australia unless it was treated as general information that a party ought to know in relation to their work health and safety obligation. So I mentioned before the difference between the primary duty under our law and the work health and safety obligation. There's certainly areas where there's an overlap, and it's possible that this code might be used as evidence of general knowledge for the purpose of that. Yeah. Western Australia also has its chain responsibility laws, but those laws are quite different from the version of chain responsibility that's now part of the heavy vehicle national law. Okay. So in short, no legal effect in Western Australia, but useful guidance.
Which actually probably brings me to one of my other questions, is that when people are looking at trying to answer that question of, is what I'm doing reasonably practical or practicable within this set of circumstances, and there are going to be judgment calls around that. I think the point about this code is then a line of evidence. What other, if people are then looking at other controls, what other sorts of lines of evidence would you be suggesting that maybe people should actually go to, noting that it is going to be very specific and this is not legal advice?
Other evidence to understand their own risk profile, I think.
Yeah, I think so. In terms of what, if you're looking at a different control mechanism, that's not one that's listed in the code, because maybe it's a new technology or that point of not everything is going to be suited to every circumstance.
Sure.
I'm just wondering, what's your advice in terms of how people might work that through?
Yeah, no, it's a great question. We'd recommend that people subscribe to or read or become aware of industry publications, whether that's from manufacturers or industry associations. You sometimes see knowledge at the beginning in some of those newsletters or meetings. You get people coming along to conferences to talk about a new system. So keeping on top of technological advances and research from OHS and WHS practitioners. Sometimes you find useful advice from another industry. For example, the mining industry is an industry that's often been well ahead in terms of safety because it's such a dangerous industry as well, and that's important for them. Australian standards, codes of practice from other jurisdictions, and information from your own business. Look at your safety records. When has there been an incident before? What worked? What didn't work? Speaking to your business partners, your employees, anyone, I suppose, that has information that's relevant to you. So to go back for a minute to the executive due diligence duty, part of that duty is to keep up to date with safety information. So that requires an executive in particular to be inquisitive, to be looking for information, to be proactively finding out what's out there. If we've done our job well, though, the code of practice goes a long way to capturing a lot of it, but of course we can't capture all of it, and things change.
Yes, and I should say actually, the document has moved a long way from the earlier versions, and thank you so much to the NHVR and your team for the work that you put in, because it is quite a much more streamlined document. It is an easier document to engage with, I believe. So, but we'll continue to gather our feedback and provide that to you. So Pete Bother asks, what chain of responsibility role applies to third-party customers? So in this case, particularly delivery, where the delivery receival point, sawmills, in particular around things like mass management and providing a safe work environment for drivers delivering logs.
Yeah, there's a section towards the end of the code that describes the activity, I think, receiving logs, and that's very much focused on what those businesses should be doing. So there's a number of things they should be doing and a number of things they shouldn't be doing. So making sure that, for example, in relation to fatigue, making sure that there's good management of the queue, that there's information in advance about how long it will take, and those real-time updates if there's going to be delays. Those are all things that help manage fatigue or help drivers manage fatigue. Provision of premises or rest facilities, if that's available. We've recommended perhaps a slightly different approach to looking at monitoring mass. We've seen in the past a practice that was sometimes quite punitive about overloads. I believe that the approach that was taken in the past was a consequence of the earlier version of the chain responsibility legislation. I mentioned that earlier, but before 2018, chain of responsibility was based on extended liability, where if a driver was in breach of, for example, a mass limit, then all the other parties in the chain of responsibility were deemed to have also committed that breach unless they could raise a defence. And I think as a consequence of that legislation, which was around for about 20 years and which is still in place in Western Australia, as a consequence of that, a lot of businesses, I think, went perhaps a little bit too far in trying to monitor the compliance of drivers in particular. And sometimes the consequence of that is banning drivers from sites, banning companies from delivering. And the problem with that approach is that it's getting rid of experienced drivers, experienced companies, when the risk is relatively minor. So I'm talking about minor overloads. I'm not talking about overloads of multiple tonnes, but I'm talking about a 250 kilo overload or something like that. In particular, this is an issue because the circumstances where vehicles are loaded sometimes makes it very difficult to get an accurate measure of the load, of the mass of the load at the time, because even onboard mass isn't always accurate unless you've got very flat level ground. I think I've answered that question, have I?
Look, I think so, and but I suppose my follow-up here, which you point to, is that one of the issues about chain of responsibility is that everyone plays a part, but everyone plays a slightly different part. Does everybody have to know every other person's job?
Everybody has to do what's reasonably practicable. So that means they have to take measures that are proportionate to the overall risk. When we're talking about risk, we look at the most important risks first. And that tells you that things like fatigue management and load restraint are far more important than mass management. Because although overloaded vehicles eventually cause destruction of pavement and long-term damage to bridges, but they're not those critical safety risks that are going to cause a vehicle to collide or to roll or for a load of logs to come off.
I suppose my sort of supplementary question is, to what degree would, so for the sawmill, for example, as delivery agent, need to understand the constraints of the truck driver, for example, in terms of addressing things like the code and compliance? Is there needs to, it would seem to me there needs to be a level of crossover, but not necessarily an expectation that's going to be in-depth knowledge.
I think that's a fair summary, because operators of heavy vehicles also are parties in the chain of responsibility. And so what's reasonably practicable for the transport company, of course, is quite different from what's reasonably practicable for the sawmill in terms of what the driver's doing. You know, training of the driver, knowledge of the vehicle, knowledge of the limits, knowledge of the access provisions that relate to that particular vehicle. Yep. So I'm not saying that sawmill operators, for example, shouldn't know at least generally what the mass limits are that apply to heavy vehicles. But we wouldn't expect a sawmill operator, a person at the Weybridge sawmill to know in detail, you know, this is a PBS vehicle and, you know, these are the conditions, it's got these sort of tyres, it doesn't have, you know, Euro 6, so therefore it's got this, but we don't expect that level of detail. We do expect a sawmill operator to go, hang on, that looks like about 52 tonnes, that's too much. So it's just that difference in their capacity, I suppose, to have that detailed knowledge.
Yeah. Which is also then an interesting question about to what extent does, if you see something, say something, come into play? Because other parties aren't the regulator. The regulator, you have your particular job, you have your compliance officers, you have the people that need to come in. And there is that issue of, yes, well, what's reasonably practical for this, every party along the chain for their job. But is there this is actually probably now beyond the code, but is there that requirement or expectation around, you know, if there actually are problems, you should report them?
Yeah, I agree. So I wouldn't say there's a strict legal requirement to report something. And in Australia, in most states, we don't have a duty to rescue, for example. But when we're talking about that primary duty, was it reasonably practicable to train your staff to call things out, record them, observe, record, report? Absolutely. I mean, it's not hard to do. We don't want every single person to be trained as a policeman, but we do want people to be trained enough to know that looks dangerous, I'm going to tell somebody about it. And as I said earlier, safety is a system, and the critical part of that is usually information, getting the right information to the right person. So it's very difficult for the transport operator, for example, to make sure that their drivers are well trained, that their vehicles are safe, etc., if they're not getting that feedback. So we definitely encourage that. And we've heard from many operators that that they work together like that 3 or 4 different transport companies, they're competing for the business, but they're also in it together, and they share information with each other. They share information with the forest owner. They share information with the mill, and all of them work together, and that's how you get safety.
Awesome. Now, without notice, Chandru, I've actually activated your capacity to speak and turn on your video if you'd like to, just because I wasn't quite sure that I was going to actually get the content of your question right. So please do feel free to jump in here. The question is, the controls list in the draft code of practice do speak to that issue of you've got to have a flat surface for loading. And we're talking about areas that are often not flat, or at least they're not flat to start with, and then they need quite a bit of work done on them to achieve that. So the Chandru's question is around this can be really problematic because of issues of weather, remoteness, erosion, geography, all of those sorts of things. Chandra, I don't know if you've got you're able to jump in, but the question is, will you be open to looking at this further, or is it a response that, again, the code is guidance, not prescription?
Yep. In a nutshell, Tim. And actually, we've had written feedback from another forestry company that says, look, we just can't achieve that, or we can't achieve it, without building roads and so on. And we understand that. We also understand that if you're trying to manage water runoff, to stop mud building up, you can't get good water runoff if everything's perfectly flat. So we do understand that. As Tim said, that's a goal, and it might not be achievable in all circumstances for all businesses. So if you can't get that perfectly flat loading area, then you have to look at other ways to get that information or to manage that. For example, one thing you could do would be to get that feedback of how much did all of those loads weigh at the end of the day. Most loads end up going somewhere where there's a weighbridge. Get that feedback. Of 200 loads that we did today at our coop, 185 of them were below the limit, 10 were up to 300 kilos over, or whatever it is, and 5 of them were 2 or more tonnes over. That tells you you've still got something to do. So there's more than one way to skin a cat, and if you can't implement one of those controls perfectly, then look at other controls you can put in place.
Great. Chandru, do feel free to jump in. I'm not sure. I can't actually see whether you're on mute or not.
So
anyway,
thank
well,
you very much. Yeah, so that answered my question. It was more relation to just one control listed. I just wanted some clarity, that's all.
Okay.
No worries. Great, thank you. So now, Mark Hitchens, I'm doing the same thing for you. So we're without notice, I've given you the capacity to turn on your mic and camera if you so choose. Mark's question is, Jinker and pole trailer are only mentioned once in the code at 10.3.1. Always love a direct reference. Will this be expanded to better capture restraining timber poles, both hardwood and softwood, that can be up to 30 metres long?
Good question, Mark. I don't have an answer for you off the top of my head. I might ask hello, Mark, I think that you're there. I might ask Craig Minns from my team if he would like to comment on that.
Yeah, so I've also just activated Craig's camera and video, and he should be online just momentarily. There he is.
Yeah, good day, everybody. Thanks for the question. The issue with timber and with pole and jinker trailers is that the restraint on the dolly is effectively restraining the dolly to the logs rather than the logs to the dolly, if you know what I mean. The poles can be well restrained at the front end of the truck, but there's, as we know, a fairly loose connection back to the dolly, and so we don't believe there's a substantial risk, and you may have other evidence on this, but we don't believe there's a substantial risk of logs sliding off the back of a jinker, for example, and there's very little risk of them sliding out the side if they're loaded up against the headboard. So all we suggest effectively with jinkers is to make sure that the jinker is that the front of the load is well restrained, so it can't move around much, and that the logs are restrained to the dolly, but make sure that you've got a headboard on the trailer. That way, we think you'll have managed the risk pretty well. Once again, it's up to you, but that was why we didn't go down that path of providing a huge amount of guidance on the jinker and pole trailers. Does that cover the?
I think it does. I think this draft looks to be a lot less onerous than the previous draft in terms of lashings and requirements, and it's putting a lot more responsibility back on individuals, which is probably the right way to do it. So yeah, I'm pretty comfortable with that response.
No worries.
Terrific.
Thanks for the question, Mark. Sorry to butt in again, Tim. You've just reminded me of a comment I wanted to make earlier, and that was just to note that in the previous version, the previous draft of this code, there was some very, very prescriptive recommendations about the types of tensioners that people should use, and some detailed recommendations about the number of lashings per tensioner and so on. And although I think that guidance was well-intentioned and was certainly useful for some part of the industry, the overwhelming feedback we had on that draft was that it was too prescriptive, and as Mark said, that it tried to, take responsibility away from the person. Instead, if you look at, I think, section 4.5 and 9 of the code, those are the sections that deal with load restraint. And the chief recommendation is to make sure that your equipment is sufficient to satisfy the vertical performance loading standard. In other words, that if you're meeting that one, you're probably meeting the others. So that's that guidance sounds simple, but it may require many businesses to increase the number of tensioners that they use or to improve the performance of those tensioners. But as I said before, load restraint is an existing legal obligation. It's been part of the law for decades in this country. So we're not really adding anything new there. We're just trying to help provide that information and guidance. All right, I'll stop there.
No, wonderful. Craig,
Do you mind if I just jump in here, Tim, briefly?
Yeah, go for it.
Just on that topic of loading performance standards, one of the things that emerged from the testing that we did was that it's very problematic to assume that there is adequate clamping force being applied to every log in a load, no matter how much force you apply to it. So there's always going to be some logs that will be that won't be adequately clamped and may be prone to moving. So the main concentration in developing the loading guidance was to give advice that is designed to make sure that the logs that do slide are going to be stopped by something before they escape the truck. So a headboard or a tailboard, that the logs against the stanchions are well and truly secure and are incapable of sliding past the stanchions. And whilst that may not guarantee that you'll always get to your destination without losing a log, it's a pretty good approach, and we think it will really reduce the incidence of these types of incidents.
Yep, brilliant. Okay, we're very, very nearly at time, so I'm going to give one more call out to both you and Jennifer and Craig, if there was anything that you wanted to make as a final comment.
Send us your feedback.
Which is probably my next point. Yes, what is the best way that you would like to receive it?
We have a page on our website, and there's a QR code on slide 2. Or you can go to the National Heavy Vehicle Regulator website and go to our Codes of Practice page, and you'll see a form that you can fill out to provide feedback. You'll have access to the draft, our web, and our email address is there as well. So if you don't want to use the form, just send us an email to codes@nhvr.gov.au or use the form. It's all there on the website.
Absolutely. And of course, for AFCA members, please send your feedback to me and I can collate that for us to present a collective submission through to NHVR. So thank you very much, Jennifer, and thank you, Craig, for your involvement today. I do hope that people have found this useful and informative. I have actually at the start I said I wasn't going to do this, but I have actually just added a little poll so that if you did find it useful or not, let us know, because your feedback is really helpful for us to actually know how we should structure these activities, when we should do them, all of those sorts of things. So I do really encourage you to please provide that feedback to me. If you are interested or need more training in chain of responsibility, on the 14th of May, AFCA will be holding a members forum on the Gold Coast, and we're actually having a workshop with NHVR on chain of responsibility specifically. So really looking forward to that. We'll also have a dinner that evening. That's Wednesday, the 14th of May. It's on the Gold Coast to then facilitate people who either want to go to the Brisbane Truck Show, which is on that weekend, or the Primex Field Days down in Casino. If you're not an AFCA member, please join. Membership is actually how we operate and what gives us the funds to do it. If you like what we're doing, please sign up to our newsletter and we can keep you updated on that. With that, and we are at time, so I'll draw us to a close. Once again, thank you so much, Jennifer and Craig. I've really appreciated this, and we'll look forward to getting our feedback through. Thank you so much.
Thanks very much, Tim. Thanks for everyone attending.
Cheers.